like the professors were too.
And they're like, oh, I've been saying it wrong for 10 years. So I was trying to get that. Yeah.
My mother's middle name is Mary.
My kids teasing me about this play called Ariel. Never gonna go away. Actually, someone in my office was saying, why don't you just change your name? Look, I can really live with this problem. You guys are ready to start? Sure.
We're ready.
Well,
Okay, that's fine. You can answer them too.
Actually, Illinois does.
I was doing more. Yeah, true. Yes, they give you the donut. This is actually good for Sunday. I wasn't sure. Yeah. So whatever you were doing. Exactly. I was like, darn, we're right after that.
I'm leaving really quick in the morning. Delta. I've done that. I used to do quite a bit, so much so that
my passport failed.
But it's actually fine. I haven't done anything.
yeah, no,
Flying back to
Yes.
Oh man, we're gonna get back. Yeah, I did. I'm from Maryland.
Thank you for coming to this panel. Today we have two very distinguished speakers. The first will be Miriam Engelman-Lotto, who is the chair of the Environmental Health Practice Group at Earth Justice. Second is Dr. Paul Locke, who is an environmental health scientist and attorney and is an associate professor at Johns Hopkins University Bloomberg School of Public Health in the Department of Environmental Health Sciences, Division of Toxicology. Please join me in welcoming them.
I'm so excited to be here. I'm so glad you're all here. On a Sunday, I thought the room would be empty. So So this is great. And I also think that this conversation today is a continuation of a conversation that happened in this room yesterday about how folks doing work on environmental protection and folks doing work on public health and animal protection can work together, and how do we forge a dialogue even around tricky issues. And I think that's where I would situate this discussion. So briefly, I'm at Earth Justice. We are an environmental organization. I work on issues about human health and environmental health, so toxics, pesticides. Actually, a big chunk of my practice is on CAFOs, or confined animal feeding operations, which was discussed yesterday. And after today's session, I'd be happy to talk to anybody about CAFOs, which is an issue that's important to me. And where we're going today is to talk about toxics and the issues in common and the tensions, and how do we forge a dialogue with enough trust to move forward. I have two pictures of my adorable dog, Dusty, up here, because I think for many of us, issues of toxics need to be brought home. Sounds very abstract, toxic chemicals. And one thing that happened to me that drove home the relationship between toxic chemicals and animals in particular was about 7 years ago. I had another little dog, Ellie, and she passed away. We were on vacation, and I think she ate some chemicals that were in the garage of the place we were staying. And it was actually horrible. You know, it was just heart-wrenching. And I think we have to keep that in mind, that chemical is going to be my theme, really, that toxic chemicals are not just killing people and hurting us and giving us chronic conditions, but they're killing animals that are pets, animals in the wild, and that's really what I want to talk about today. So often we think about the issues of regulation of toxics and the lab testing and how we approach lab testing, but I also want to open up that frame to think about the failure to regulate toxics and the impact on animals. This is I was walking around Portland a little early here the other day, and I saw this billboard. And it is Saving Pets from Toxic Treats since 1973. It's an ad for an animal medical center, and it obviously is assuming that there are toxic treats. And what I want to propose is that we don't only want to advertise for medical centers that will treat our pets after they've been poisoned. What we want is a regulatory scheme that will prevent poisoning. We want a regulatory scheme that is aware of what are the toxics in our environment, that will have knowledge about their toxicity, that will do something about their toxicity, which we might call regulation. The issue of toxics, as I said, is often pitched as a dichotomy. Animal rights activists protecting animals used in lab on the one hand against environmentalists. That's not where we are. This billboard suggests we have to be concerned about the impact of toxics on both individual animals and, I would argue, also species. Okay, so what do I mean by toxics? This is from the American Chemistry Council. They say chemistry is everywhere. Everything you hear, see, smell, taste, and touch involves chemistry and chemicals. Well, that's true. That's absolutely true. Then if you plunge further into ACC, American Chemistry Council websites, you see water is a toxic, or water is a chemical. And I think all that's true, but what we're concerned about is toxic chemicals. It is true that not all chemicals are toxic, not all chemicals in combination are toxic, but it becomes a method of creating uncertainty and a method of obscuring toxicity to start with the position of, gee, let's not worry about toxics, there's way too much concern. Toxics are like water. Indeed, in the United States, there are more than 80,000 chemicals that are listed on our inventory of chemicals that at least at one point were in commerce in the United States. About 64,000 of them were around at the time that TSCA, the Toxic Substances Control Act, which is our main regulatory structure, was enacted in 1976. And about 24,000 chemicals have been added since then. Incidentally, of those 24,000 chemicals that have been added since the time that TSCA became effective, 17,000 of those are secret. That is, there's an inventory of chemicals in commerce, and when a manufacturer or importer wants to introduce a chemical in commerce, it can say, I'm going to introduce this chemical, but I'm not going to tell the public what it is because I don't want my competitors to know. And I'm going to call it confidential business information. 17,000 of the new chemicals added into commerce since TSCA was passed are secret. So we may be exposed to them, but we don't know what they are. Why am I concerned? Well, there are a whole host of reasons that toxic chemicals can affect humans, animals, pets, and animals in the wild. The most disconcerting chemicals are PBTs, persistent, bioaccumulative, and toxins. These are just some examples, benzenes, PCBs, you might know about them. Persistent means it stays in the environment, it doesn't degrade. Bioaccumulative, it accumulates as a substance in an organism, and then it may be passed on to the animals that prey on the other animal. And of course, toxic means it presents some hazard. There are lots of chemicals that are also toxic and may not be persistent, but because we're exposed to them on an ongoing basis, we're continually getting more of that toxic in our system, and it can have a long-term chronic effect or even an acute effect at some time. So why are we concerned? We're concerned about these toxics because they cause effects on the systems of humans and other animals. They can be endocrine disruptors. You've heard about gender bending and the problems of endocrine disruptors, particularly on amphibians. Reproductive toxicity, carcinogenicity, neurotoxicity, toxics that affect the development of juvenile species. And note that toxics can have acute effects. You can be exposed to something and all of a sudden feel itchy or have eye problems, or that's true for animals as well. Or they can have long-term chronic effects. It may be that you don't feel it right away, but over time being exposed may cause health impacts. And also it can have an effect on an individual and an effect on a species overall. So I'm just really quickly going to talk about a few studies just to hit home on the issue. And some of you in this room may be more knowledgeable about any one of these studies or any one of these species than I am, but just to give you a sense of it. So this is the Spur Whale. I have this up here because when I first came to Earth Justice about 4.5 years ago, the BP disaster was unfolding in the Gulf of Mexico. And one of the first things I did was go down to the Gulf of Mexico and talk to people about what are they concerned about with the disaster. And one of the things they were concerned about were these toxic dispersants that were being applied in unprecedented levels over the water, and then for the first time subsea they injected these dispersants. And the dispersants were intended to break up the oil. When it broke up the oil was still around, and it just went into the water in teeny little droplets. And what they found, first from the experience with the Exxon Valdez in Alaska and then with BP, is that these teeny little droplets are more bioavailable. They go into the skins or equivalent in animals, and they've affected juvenile species of all kinds. They affect coral. They affect any number of animals. And the research is still being done on the effect on species and individuals in the Gulf. So you didn't see this bird covered with oil. What you didn't see was under the water. It was out of sight, kind of out of mind. And so we started to look into these dispersants, and it turned out that a number of the chemical ingredients in dispersants were proprietary. That is, they weren't known. So you couldn't even look at the research to make an intelligent decision about which product to use because they were confidential. So one of the first things that we need to talk about in terms of common agenda is working on this confidentiality issue. It's a huge issue. The sperm whale is one of the casualties of the use of dispersants. In the aftermath of the disaster, they found that genetic information in the skin cells of sperm whales was affected by the dispersants, again, among other effects on species and individuals. Of course, bees has been in the press a lot. I don't need to tell you that we don't have a precautionary principle in the United States. So we allow chemicals on the market, even though we don't have adequate information about those chemicals, and we don't require that industry provide adequate information about those chemicals. And so we put things like neonicotinoids, which are a form of weed killer, on the market. And we say, well, in this case, gee, it seems better than other pesticides that we've used or other killer chemicals that we've used because it doesn't have the acute effects, or it's not killing people, it doesn't have some of the other effects. And then we find things like bees dying out in unprecedented numbers. And until we can prove that these bees are dying out as a result of the neonicotinoids, we have an uphill battle, and we're fighting against this sense of uncertainty. Scientists are on the trail of the cause behind this massive global bee die-off, but there is a slew of evidence that it is due to neonicotinoids. Europe is way ahead of us in trying to ban neonicotinoids, and the United States, of course, is piddling around despite this incredible change in the bee colony because we don't adopt the precautionary principle. Bottlenose dolphins, studies have demonstrated the bioaccumulative nature of many toxic chemicals and the dangers of underregulation even after the substance has been banned. So there are substances like DDT, which the whole controversy around DDT was a major move in the environmental movement, but nonetheless it's still around. And one study found, for example, 26% of dolphins in a particular location on the Georgia coast were anemic. And there's a relationship with their exposure over a long period of time to DDT because it stays in the environment. The ring-billed gulls in this area of Quebec are the most contaminated colony in Canada because of flame retardants. Now, there are different generations of flame retardants. Some flame retardants have been phased out, and then you have new flame retardants that come in that are inadequately tested, and then we find out that, wow, these flame retardants are awful too. And then it takes a new battle to get rid of them, and that's kind of where we are in the flame retardant discussion. But these ring-billed gulls were poisoned. They have reduced clutch size, damaged eggs, weakening bones, and other impacts of an earlier generation of flame retardants, which again has a continuing impact. Just a couple more examples. The brown bullhead. This other area is designated an area of concern in Canada. There's greater tissue concentrations of PCBs. Again, a chemical that is being regulated now, but we see the legacy effects of these underregulated chemicals. Harbor seals in the state of Washington. They exhibit 7 times higher level of PCBs than seals in other areas, linked to variation of the PCBs in their food basket. Killer whales, significant health risk associated with PCB burdens. What I want to say about this is that sometimes the results of using chemicals aren't apparent at the beginning. That it's because of long-term chronic exposure that you start to see what the effect is on individuals and species. And this is such a case. Population-level effects are only evident after several years, which suggests you actually have to have different kinds of testing that are often done by industry and by, and by the government. The snapping turtle is, again, another example of PCBs and long-term effects. The caiman. This is bisphenol A. Bisphenol A, right now, you must have read about over the last few years, has been in baby bottles, but it's all, and in many states, there's an effort to get rid of it in baby bottles, and actually the Food, Drug, and Cosmetics Act has been used to try to regulate bisphenol A in baby bottles. When you say baby, people go, ooh, babies. But it's also in receipts. It's also in the tanks of our water. It's also, if any of you have a can of Diet Coke or something, in the lining of those cans. Bisphenol A is really all around us. And it causes this estrogen-like effects to the reproductive systems, not only of people, but also of animals. And this is an example. Polar bears. This is again an example of effects as a result of flame retardants. So, why can't we do a better job of regulating toxins? They're bad for us, they're bad for animals, they're bad for the environment. Not always, but they can be, and so we need to know which ones have what effects, and we need to do something about it and give the government the ability to regulate appropriately. At the federal level, toxic chemicals are regulated under a number of different statutes. I'm primarily going to focus on TSCA, but of course cosmetics, food, pesticides are under the Food, Drug, and Cosmetics Act, or FIFRA, which regulates pesticides. But the key law intended to regulate chemicals is TSCA. It grandfathered in 64,000 chemicals that were in commerce at the time that the law was taking effect, which means that these chemicals never had to be reviewed one at a time by EPA to determine whether they're safe for us, for animals, for anyone. It never required a minimum data set to this day. If you want to put a chemical in commerce or sustain a chemical in commerce, you don't have to say to EPA, here's how we know it's safe. That's just not the way the law works. Even worse is that there's been weak implementation. So even where EPA has authority to collect data, or has authority to reveal data to the public, or has authority to regulate, it's been attacked by industry. The state of play now is absolutely inadequate information about toxic chemicals out in the market and inadequate protection against risk. After the oops moments, like baby bottles with bisphenol A, you get some fear building up in a community and you might get attention to that one chemical. But there is broad-based industry attack to create a sense of uncertainty and to prevent regulatory efforts. The policy of TSCA was manufacturers should develop data on the effects of chemicals, but it wasn't mandatory. Government should regulate chemicals that create an unreasonable risk of injury to health or the environment, but the regulatory authority has been grossly attacked. And I'll just, some of you may know about this case. A couple decades ago, EPA spent about 10 years reviewing the effects of asbestos under TSCA. And they basically banned asbestos. And that was it. You know, they kind of figured if they can't regulate asbestos, what can they regulate, right? Everybody knows asbestos is carcinogenic, et cetera, and there was exposure to asbestos. And industry attacked that and said, well, there were some uses of asbestos, like in ball bearings in tires, even though tires do explode, onto the roadway. They said, well, it's very unlikely anyone's going to be exposed to that. And on that basis, the appellate court struck it down. And essentially, because TSCA says that if they're going to regulate, EPA has to use the least burdensome form of regulation. So if you're going to ban, well, could you regulate? If you're going to regulate, could you just have a warning label? If you were going to have a warning label, could you do something less? So there's always something less in scope or less in kind. And so EPA said, look, if we can't ban asbestos, we basically can't do anything. So it's basically left its Section 6 regulatory powers on the table. And there's some efforts right now to get that going, but it's very weak. So quickly, EPA has Section 4 testing authority, where by rule, where there's an unreasonable risk of injury or an insufficient data, EPA can require testing necessary to develop the data. But look at all the qualifications there. They first have to find there's an unreasonable risk of injury. Well, if they don't have the data, how do they find that? Right? I mean, it's circular. Section 5 for new chemicals has no minimum data set. Section 6, I already talked about. This, the chemicals will present an unreasonable risk of injury, and they have this least burdensome requirement. So there are holes big enough to drive a train through. There's my picture of a train. So we need reform. And the conversation we need to have is, how do we work together toward reform, and how do we work together to move away from animal testing, but to have sufficient, robust data so that we can defend and sustain the kind of regulation that will be protective of animal, human, environmental health. We need to enhance EPA's role in ensuring that chemicals are safe, develop and apply criteria to identify and regulate chemicals of concern, require hazard information as a condition for existing chemicals to remain on the market or on new chemicals to enter the market, shift the burden to industry to ensure chemicals are safe, ensure safety standards take account of vulnerable populations. We can talk more about that if that's an interesting Q&A. Promote the development of safer alternatives and enhance the public's right to know, so that we're not in a situation where we have 17,000 new chemicals that are confidential. Let me just give you a quick example of one of the cases I've worked on that just drove home to me the complexity and also the level of industry attack. I already talked about the asbestos case, corrosion-proof fittings, but this is a case that's a little bit less over the radar screen, a case where we jumped in on behalf of a range of groups, the United Steelworkers, Environmental Defense Fund, Occupational Doctor, to defend the government's effort. In this case, it was Health and Human Services effort just to list styrene on the report on carcinogens. And they were listing styrene not even as a carcinogen. It was a very conservative listing, but as reasonably anticipated to be a carcinogen. That first of all, it drew all kinds of attention by industry. They went to Congress, they went to the administration, they said, stop this listing, it's going to freeze all sales of styrene, it's going to affect the industry, you shouldn't do it. They went to Congress and said, you should freeze any money going to HHS to do this report on carcinogens, you should have a National Academy of Sciences study, et cetera, et cetera. The report on carcinogens came out. Styrene was listed as reasonably anticipated to be a carcinogen. I just want to say this was an extraordinarily thorough report. The review of studies included 550 studies, and it included epidemiological studies for humans, included all kinds of animal studies, included in vitro studies, included everything. And there were consistent findings of a relationship to cancer. There were 4 review panels, 32 peer reviewers. Of those 32 peer reviewers, they were unanimous, except 2, which I'll mention in a minute, that this should be listed as reasonably anticipated to be a carcinogen. The 2 that dissented wanted it to be listed as a carcinogen. Nonetheless, DART and the styrene industry brought this case in court, and they literally threw mud on the wall. They said the peer review was flawed because it included analysis, that peer reviews don't include analysis. They were talking about the data, and by talking about the data, they were rearranging the data. They said there was an appearance of bias by a reviewer. They said there was a failure to weigh all the evidence because there was some evidence they sent in that didn't make it to the top of the stack. And they said that the memo to the secretary describing the analyses and describing all the studies failed to provide her with every study that they could have provided. So she didn't have perfect information to make this listing decision. It was ridiculous. But, you know, and we won, yay. But give it to you because to me, that's a frivolous lawsuit. But they are just so intense in defeating any regulation, any listing, and to suggesting that there is not a basis for regulation. And so when we think about what kind of obstacles we put in the way, even though they're justified in some way, we have to think carefully about what effects that will have on the protection of individuals and species, animals and humans, right? Because it isn't just, gee, on the one hand, we're protecting lab animals, and on the other hand, everything's fine. So it's not all about, there are many obstacles to regulation, as you see. I mean, they even use lab animals, and they still have these problems. But we want to think about how we broadly, as a larger set of communities, how we come together to address this lack of regulation. Okay, so we need better policies to help animals. Here's yet another example. Otters living 1/3 as long as their counterparts when they're in Scotland because of the presence of cadmium, mercury, and flame retardant. So the questions for discussion that I'm hoping we'll get to, if you all, we can talk about how chemicals affect animals, but if you're on the same page that it seems self-evident that chemicals affect animals, the questions we want to get to are, how do we get to better policies and what do they look like? How do we ensure that all efforts are made to reduce animal studies and at the same time that procedures are put in place not only to limit animal studies, but also that this doesn't become a barrier to collecting information and a fodder for industry challenges to the validity of any listing or regulation. What is the state of the science, and how can we support listings and defend listings, more information to the public, and regulation with fewer or no animal studies? And what do we do to minimize animal studies without jeopardizing appropriate regulation? With that, Paula.
Well, thank you very much, and good morning. And since I've been portrayed as somewhat of a scientist, I have to write some numbers on the board to start out with. I'll go through these numbers during my presentation. So the first number is, or for those of you that love scientific notation, 3 times 7 times 10 to the 5th. Check me on that. Then 2 years. The first numbers of years, 36 years and 70 years. That does not refer to my age or the age of anyone in this room. And then one other number, 1 in 10,000, or 1 times 10 to the negative 4. So as we go through, you'll see why these are important. Now, just by way of background, these are the things I'm going to talk about today, but a little bit more about me. I am a lawyer. I'm in recovery, okay? I went to law school. I practiced law. I actually started my career on Wall Street doing complex security transactions. That is, or I found it to be about as interesting as watching cement dry. So after doing that for a couple years, I became an environmental lawyer, and I practiced environmental law in New York and Washington, D.C., and then I got very interested in the science behind environmental law, and I was lucky enough to go to Hopkins and get a doctoral degree in environmental health sciences. And then sometime after that, after practicing law about 15 years, I came to Hopkins, and I'm on the faculty now. I'm the only lawyer in my department, and that's one lawyer too many for my departmental chair. But basically what I try to do is I do science-based advocacy. I go to Capitol Hill. I look at what happens to the science, to the experiments when they escape from the laboratory. So to start out today, I want to talk about the history of product testing and some early toxicity tests. And then I want to talk about a new paradigm, getting to some of the questions that Marion raised about how we can work together. Because one of the situations we can't be in, and I'm a faculty member here at Lewis and Clark. I teach a summer course in this, and I'm an environmental lawyer as well. But we can't be in the situation where we are having people say to us, we want more testing, and the only way we can do that is with more animals. Because that is not a good situation. And in fact, that doesn't really even reflect the best science, which is, I hope, the message that I leave you with today. But to begin, I want to ask you, I'm going to do, this is a quiz, okay? You already had your donuts, so I can't, dock you if you don't get this right. But does anyone know who this gentleman is? This, by the way, is the same guy as this. He has aged. I think he's aged well. I like him for a number of reasons. I will tell you he's a musician. I like him, though, because he's a cyclist, and he also wears his helmet. I'm a public health guy, so you got to wear it. So anyone know who this is? Who said that? David Byrne. Okay, anybody know what group he was with? Talking Heads. If they're not on your playlists, okay, they should be. And by the way, if One Direction or Fall Out Boy are on your playlist, come see me afterwards. I can help you with that. But David Byrne, the reason why I have David Byrne up here is because of this Talking Heads song. And this Talking Heads song, I'm not going to sing it, don't worry. It's important because of the last line of this song. And the last line of this song is, you may ask yourself, well, how did I get here? And one of the things I always do when I'm doing advocacy is I always try to figure out how we got to where we are. And I think Marion did a great job of sketching out the Toxic Substances Control Act and the things about the act that just simply don't work. Now, I'm going to add to that by telling you a lot about the scientific journey on product testing and how we got to the situation we're in now. And that is what I call asking the David Byrne question. But one thing I want to leave you with, one thought I want to leave you with is if you're doing advocacy, none of us as advocates are ever working on a blank canvas. We're always kind of starting the race in the middle and trying to figure out how we got to where we were. And for me, it's been very valuable to figure that out because it helps me know how I can help people get to where I want them to be. So, how did we get here? Well, we got to where we are because of some truly wonderful products, and I use wonderful sarcastically, of the early 20th century. And I'm going to talk about a couple of those really quickly. The first one here is called Elixir of Sulfamide. I'm going to talk about that in a minute. But this is one of my favorite ones. I work a lot on radiation issues. I don't like controversial issues, animal testing and radiation, right? And this is a product that came out, it was produced, I think, between like 1915 and 1923. It's called Radithor, and it was certified to have 1 microcurie of radium and thorium in it. Now, so what is a microcurie of radium and thorium? It doesn't sound like very much, but just to give you an idea of how powerful that is, if you go today and look in the literature and you look at the regulatory limits of radium, it's around 5.4 picocuries. So that brings me to my first number here. A microcurie, 2 microcuries of radium, is 3.7 times 5 more powerful than the standards now. And by the way, what were you supposed to do with this? You were supposed to drink it. It was going to give you energy. And you know, when you did drink it, it gave you a tingle. Unfortunately, it also caused your bones to disintegrate, and people who used it regularly died horrible, miserable deaths. So, and there was, by the way, no litigation around this. But this was, again, put on the market and advertised. Now, Elixir of Sulfamide, unfortunately, has a similar history. Sulfanilamide turned out to be very effective against strep. Remember, we're now in the 30s here. We don't have antibiotics. And there became a call to put this into a liquid form because liquid form could be more easily digested by children. Well, the manufacturer of this dissolved it in ethylene glycol, also known as antifreeze. Okay? And marketed this and bottled it without testing it, and it killed many people, including a lot of children. And there was a massive public outcry. And I think you made this point about the fact that especially when you start to have something that impacts children, the public really, really gets incensed. This is an article that you can't see very much of, but it's from the 30s, from 1937, pointing out that the government was trying to recall this stuff and they couldn't even get it off the shelves fast enough. So this was a massive failure. My last one, and this is to some extent my favorite one, this was a situation dealing with mascara. And apparently, I wasn't around then, okay? But in the 1920s and 30s, this is what you were supposed to look like, I guess. You know, you're supposed to put all this mascara on. And somebody got the bright idea that you should use aniline dye to dye your eyebrows. And what you would do is you'd go to, what some people would do is they'd go to a beauty salon, they would cut your eyebrows down, and then they would put this aniline dye on it. Unfortunately, when that happened, some people would spike an atypical reaction, and the aniline dye would cause them to swell, their tissue would inflame, it would become infected, they'd get sepsis, and they would die. Now, I don't know about you, but I don't think people should die from using cosmetics. So these are the sort of serious things that happen. This is an article, Fatality Resulting from the Use of This, from the Journal of the American Medical Association, a very prestigious medical journal from the 30s. Okay, so why is this important? Well, first of all, it's important because what you see happening here is you've got a situation where we are actually experimenting directly on the public. We are not testing at all. So that became clearly something that we had to battle against, and it coincided with the election to the presidency of a gentleman named Franklin Roosevelt, Theodore's cousin. And that was something that is important because, as I'll show in a minute, he federalized a lot of the laws. And that's why product testing is federal. It's not state. We don't have any state product testing laws. We've got federal laws on this. But it also resulted in the passage of the Food and Drug and Cosmetic Act and the development of something called the Draize test. The cosmetics in particular led directly to the development of the Draize test. And the Draize test uses bunnies. Okay? And that test was developed in 1944. Okay? So has anybody here heard of the Draize test? Right. It's a very infamous test, especially in the animal protection community. And it's a test where you immobilize rabbits and you actually put into their eyes compounds, and then you score how badly the compounds have damaged their eyes. Now, let's assume that this was good science in 1944, okay? I don't think that we can argue about that, and in fact, the argument is pretty moot, but it really doesn't matter. Because 1944 was how long ago? 70 years ago, right? I did the math here, okay? You don't have to. 70 years is a long time, right? In science, and it's a long time in law. So even if it was good science 70 years ago, the question is it good science now? And that's a really important question from my perspective as a science advocate, because I want the United States and actually the world to use the best science to make decisions about toxics, about medicine, about all sorts of products. Just going back to the impact of law, what you do see, I think, is a federalization of product testing, and then as federal administrative law rose, you find that what we have is the evolution of a federal system about how animals were used in research and testing. So keep that in mind, because my work is with the U.S. Congress, again, because we have a federal system that looks at how animals are used. We have TSCA. That's where the action is. Now, let's go back to 1944. Again, a little quiz here. Anybody recognize this picture? Casablanca, thank you. I know you law students haven't been watching classic movies. You've been working too hard. But that's Casablanca. That won the Academy Award in 1944. I looked it up. D-Day. Okay. This is what trucks look like in 1944. And apparently big things are ahead. Now again, in 1944, we had a certain level of science. And the most sophisticated science we could probably get then was to test on rabbit eyes. But we're 70 years out from that. And in fact, even by 1980, which was 36 years after the Draize test, a very, very famous animal activist, Henry Spira, asked the question in the New York Times, how many rabbits does Revlon blind for beauty's sake? Taking direct aim at the Draize test. So, by 1980, there was already questioning about whether we were doing the best science. And this, by the way, resulted in a real rethink of how we do testing and how we use animals. Now, let me just go back to TSCA for a minute, because Mary did a great job of talking about TSCA. The point I want to make is that in TSCA, there is no testing required for chemicals that were in existence when TSCA regulations were put in place. I think that's right, in 1980. And even for new chemicals, you have to put forward something called a PMN, a pre-manufacturer's notice, but you don't have to provide any data. Imagine that. I actually have a graduate student. He just finished his doctoral dissertation. He went back and he looked at TSCA filings, new chemicals filings, and there's like no data in most of them. He found 36 that were public, most are not. Just no new data. So the bottom line is you don't have to test. And what that means is that we have a really poor toxicity database for almost all chemicals on the market. Now, let's say conservatively, we have good toxicity data for, let's say, 50 of the chemicals, and let's say conservatively that there's 50,000 chemicals in active use. And those numbers might not be exactly precise, but they're roughly correct. That means that for 1 in 10,000 chemicals, we have good toxics information. All right? I don't know about you, but that doesn't make me warm and fuzzy. That's not a good thing. So we have a massive toxics information gap. Now, TSCA discussions for amendments are underway on Capitol Hill, but they are extremely bogged down in politics. And I don't want to be a cynical person, but I don't expect anything to happen in the next legislative session, maybe even the one after that. So the discussion goes on, but frankly, we don't need to wait for TSCA reauthorization to do better science and as advocates to make better science happen. And in fact, we have an ally here, and that ally is the National Academy of Sciences. In 2007, EPA asked the National Academy of Sciences to go over their toxicity testing program and suggest changes. And the Academy came out with these 2 reports. This is the final report. The report over there is the interim report. But this report, Toxicity Testing in the 21st Century, A Vision and a Strategy, laid out what this group of scientists thought EPA's toxic system testing should look like. And I'm going to talk a little about that now. So the first thing to note is that they divided the testing world kind of into 4 groups. And this is where we are now, okay? And they said, okay, you could keep with option 1, which is using animal biology, high doses, low throughput, which means the tests take a long time. It's expensive, time-consuming, and you're using something called apical endpoints, which means you're looking for the development of a tumor or a death, which is not really the most elegant science. And this is not serving us very well, the Academy said. Or the Academy said you could choose any of these other options, but the options that we like the most, the option we like the most is option 4, which is an in vitro option. In vitro meaning in cell lines, computers, not using animals. Primarily human biology organized around human cell lines, using a broad range of doses, high throughput so you can do these things rapidly, less expensive, less time consuming, using virtually no animals, looking at toxic pathways, so drilling down into the cells to see how things go wrong at a cellular level, and also using in silico screens or computer screening tools. And this is really where EPA needs to go. Now, unlike a lot of reports that are done in Washington and sit on the shelf, this one actually has legs. And EPA, FDA, and the National Institutes of Health signed a memorandum of understanding to implement this report, and they're working on that now. So that's a good thing. How am I doing with time?
About 8 minutes.
8 minutes. Okay. I'm going to finish early. I want credit. All right. So I want to go back now to where I started. Remember, we're 70 years out from the Dre's test. We're 36 years out from when Henry Spira, the animal activist, asked the ethical question, how many rabbits does Revlon need to blind for beauty's sake? And I'm translating that into the scientific question, can't we do better science? Anyone know what this is? It's a vacuum tube. So any of you go home and you turn on your iPod, your vacuum tubes have to warm up. You don't do that anymore, right? In fact, this is a picture of one of the first computers. That was I think it's ENIAC. And this is how they used to run. Now, we don't use these computers anymore, and we don't use these vacuum tubes anymore like we did in the 40s and 50s. Why are we using toxicity tests that we developed in the 40s and 50s and 60s now? We should be moving to a robotic system, and this actually is a picture of a robot from the National Institutes of Health, to a system that's based on cells, and these are cells growing in cell plates, and they have different colors because the colors indicate that something has happened, some toxic reaction has happened. This is the system we need. That's a system that we have to move to for our toxicity testing. We have a massive toxics information gap. We have very little toxics information on most of the chemicals in commerce. We need to fill that. Even if I were up here trying to advocate to you that we should use animal science, you could make the very simple argument to me that there's not enough time and not enough animals in the world, and you would be absolutely right. But even more powerful than that is the fact that we don't need to use animals if we can implement this system. So what's it going to take to implement this system? And that is what I'd like us to discuss. I'd like us to ask the David Byrne question a little bit differently. So how do we get here to option 4? And in particular, what should lawyers do to help? Because if I leave you with one thing that you remember from this presentation, I don't want to leave you with the idea that this is all a bunch of science and that lawyers can't be involved. In fact, although this is science, this is regulatory science, and lawyers have to be involved because we can help shape the system that will develop and use this type of science. So I'll stop there and open up the floor. I'll turn back the podium to Sarah, and we'll open up the floor for questions, I think.
Yes. I have a question for Dr. Block about the report from the National Academy of Sciences. When you say it has legs, what does that mean? I mean, it sounds like imminent, but that might be implemented.
So first of all, some good news. The report is available for free, and in your references for this conference, I've provided a link to the report, so you can have some light 250-page scientific policy reading and be back. It has legs. It is being implemented, but think about this. You're dealing with Congress. You're dealing with agencies that have a lot of responsibilities. And one thing that advocates can do, and I should say, my approach to advocacy is I like to call myself an aggressive incrementalist. I believe you should keep pushing, but making a lot of small steps will get you where you need to go. We have to make sure that the pressure is kept up and that this report is indeed implemented. Not all the science is ready. We don't have a full suite of tests now, of non-animal tests, that we can roll out to replace the animal tests. So we have to keep at this. The National Academy estimated it would take a decade or more to implement this. And that's not going to happen unless we really, as advocates, environmental advocates and animal advocates, work together to go to Congress and keep that pressure up.
Can I add to that before we move on? So just to add a few more details on it, it is being implemented in a variety of ways. There are a number of multi-million-dollar efforts and multi-agency efforts that are very exciting that EPA is a part of. Some they take the lead, some they don't. And they've actually been testing these, what they call assays. They test these individual tests for chemicals. And they've been moving through them. So I was talking about dispersants earlier. Some of the initial sets of assays that they used were to test on the toxicity of dispersants because they didn't have adequate information. And they've been doing some test runs to try to get some initial information. So they actually have a model. They're actually working through it. And so it's a very exciting multi-agency effort that's in progress. Having said that, when Paul says the science continues to need to be developed, I think that's some of where we need to do some thinking together. So there's an area of what are these assays? What's going on? And there's a whole discussion about whether they're validated for the outcomes. And that's important to us, because if they're not validated for the outcomes, we can do all this testing, and then when an agency goes to regulate and they're invalidated, or they're confidential and we can't use them in the public sphere in somewhere, because some of these assays are proprietary, they're given by industry, we won't be able to use them. So thinking through some of these kind of down-in-the-weeds issues. Another is how to group the assays to get a view on how the chemical impacts an organism. So it's one thing to say there was this effect in vitro, it's another thing to predict from those effects that it's going to affect the kidney or whatever else. There's also big missing data, so they have assays for some things, like what's the effect on some organ or whatever, but they may not be testing for the full range of impacts. So as terrible as it is, if somebody exposes me or 10,000 people to something, maybe 2 of us will have some impact, or we have some variation. But it's not clear whether the assays have big gaps in them. And if we just go by the assays, we won't know what are the other problems that people or animals might experience. So those are some of the big data gaps. And then there's also a question about whether this high throughput testing, saw the 4 columns. The 4th column was moving toward almost no animals and reliance on in vitro, which is where we want to go. There was a 3rd column which was using both. And whether we have to move through that 3rd column, because right now people are looking at these assays and the high throughput testing to do screening. So you basically take a chemical and you run 800 tests on it for 800 different reactions, and then some of those will show that there may be a problem, but you don't know precisely what the mechanism of that problem is, and you don't know what the outcome associated with it is. So what the agencies are saying right now is we'll use this in vitro testing for screening, but it's not good enough for regulation. We may not agree with that, but that's the kind of conversation we need to have, which is kind of getting ourselves knowledgeable enough about that to come together and say, how do we get there? And what are the real, challenges we're facing, and how do we move together on this?
And I know you guys have questions. Let me just add to that a little bit and try to explain to you why, as lawyers, it's really important that you're involved. So this brings up some other questions that lawyers like to think about. Things like burden of proof. Some of you may have heard of that. I hope you have. So who has the burden of proof or the burden of going forward? If I have an assay that indicates that something might be harmful, is it up to the proponent of the chemical to show that it's not harmful? Or is it up to the agency to show that it is harmful? That question is a legal question. That's not a scientific question. The science can provide the data, but the law has to provide a standard. So it's really, really important for lawyers to get involved. Validation is very important. The way you set validation standards is very important. The problem with validation now is that, what we're validating to, a lot of times? Animal tests. That's not what we want to be validating to. We have to be validating to human endpoints. Again, that is a lawyer question, setting up the laws and regulations and validation. So I think, understand, again, lawyers have a really important role here. Yeah, you have to ramp up a little on the science. It's not the end of the world. You're going to have to do this when you're a lawyer anyways in something, because you always have to become somewhat of an expert in what your client is working on in order to counsel them appropriately.
Yes.
Sure. My question is related to toxic substances that are used in animal feed, like arsenic and dioxins. It's a really distressing issue, but also very difficult from a regulatory perspective, because depending on when the toxin is introduced, there's, at least to my understanding, 4 different levels of regulation. So I understand under TSCA, when the chemical is produced and marketed, it would be regulated there. Then once it's in the animal feed, and let's say it rains and it runs off in the environment, the Clean Water Act might come into play. And then when it's fed to animals, the USDA regulated. And then once it gets into food itself, to the chicken or swine products, then the FDA regulates it. So I was just wondering if you had any insights on addressing the regulatory challenges of these toxic substances in animal feed.
good question.
It's an excellent question. Let me just say two things, and if I think of something better, I'll add it. One is that I think, as an advocate in this area, I try to be opportunistic. So if there are 4 points of entry, I would look at them all and say, where is there a legal hook to try to challenge the practice that will be most effective? So the fact that there are 4 points of entry is a good thing. I mean, in a regulatory sense or from thinking about sound policy, it might not be. But as an advocate saying, where can we challenge the system and where can we raise concerns? This gives us more hooks. And so in the case of whether it's antibiotics or arsenic in feed or, all of these issues, that gives us the fact that I could go a Clean Water Act route or a permitting route or, so many different routes is a positive thing, and I can examine them all and figure out which would be timely and which would perhaps elevate the issue in the public space. And, it gives you opportunities. That's one thing. The second thing I was going to say is, although I agree with Paul that an important development in this story is the federalization of these issues. There is a lot happening at the state level right now, both on the animal feed and CAFO front, and which you raised, and on the toxics front. In part because TSCA is such a weak law that many communities around the country have gone to their state legislatures and asked for some form of gap filler, some way to address either the lack of information about chemicals, and California is a leader on that, or providing a private right of action if people are exposed to chemicals, as Prop 65, and there's no warning or label. Or a regulatory system based on previous work testing and listing chemicals. Or at the state level, you can get at this, and this goes back to your question, say through state permitting processes or state bans on particular uses to the extent they're not preempted by federal law. So there are a lot of different advocacy tools that can be used, both at the federal level and on the state level, to get at toxics and to elevate the issue and educate the public.
I think I agree with your points, and I just want to make one additional point about the science. Something that shocked me, which I think should have been probably obvious, but I realized that when you practice law in a field like environmental law, you're dealing with a number of different statutes, and they all have different regulatory standards. So the same science under the Clean Air Act that may give you a very low standard for compound X, under the Occupational Safety and Health Act, may give you a totally different standard. So you may be exposing human animal workers legally to a much higher level than you are asthmatic exercising runners. So that's something else to keep in mind. And it goes to the point of understanding from a systemic perspective how these things work, which you obviously do since you described the use through the feed and the whole bit, and then opportunistically picking the best place where you can make a difference. But don't expect, the science you have is going to be the same, it's just going to lead you to different results because of the standards and the laws.
Yes. So my question is with regard to labeling. So I don't know how much you guys can speak to this, but I know a lot of products you see have this really standard warning on it that says this product has chemicals that the state of California has found to be potentially carcinogenic. Now this is on practically everything. So how useful is labeling and this sort of thing? Obviously that's for California buyers, but for everybody.
So I'll start with an anecdote. I showed you my little dog. We love my little dog. And my mom was walking my little dog we share a little place in Pennsylvania in the Poconos. She was walking the dog, and as she turned around to go back in the house, my mom is getting elderly and a bit frail of health, and between her and the dog and the house, where she wanted to go back in, was a big bear. So she picks up the dog, and because the dog is like, you can tell, it's bear food, and And she doesn't know what to do because she can't get back to the house. And also the dog, he's small, but she doesn't usually carry 10 pounds around. And we have a little shed, and she insists that we don't have any toxic weed killers or everything. And I kind of defer. They're all, with your mom, you pick your battles. But they all have like skull and crossbones on them. So she goes into the shed to get away from the bear with the dog. And she's in that shed quaking with the dog for about 10, 15 minutes. And they were barely, excuse the pun, but they were almost asphyxiated because those toxics are so strong. Now it has the skull and crossbones, right? She should know that. And then, she finally got out of the shed and she quickly took a shower and bathed the dog and they were all fine. But it's just, kind of an anecdote that explains your point. I think people don't know what that means. They don't read them. In the area of, say, pesticides, it's even worse because, the vast majority of people handling pesticides in the field are Spanish-speaking. And there usually isn't Spanish-speaking labels to begin with, and they don't even have the power to enforce the labels because they're told what to do. Go back, there may be a re-entry piece at the label. You don't go back into the field after a certain hour, but if someone tells them to go back in, they go back in, right? So labels are a very weak form of regulation. I think that's right. But do they have value? I think yes. They have value in elevating an issue, causing a discussion. If there are other restrictions attached with the label, say in the case of pesticides, if there's some enforcement of that re-entry level, that can be effective. So they're a piece of the puzzle which I wouldn't dismiss, but they're a weaker form of regulation, obviously, than other forms.
I just wanted to add a little to that. I do a lot of work with risk communication, and I'm more on the radiation side than on the chemical side. But I think what you're talking about in terms of labels is correct. When a label is on everything and says everything is dangerous, it loses its power. That being said, in California, this all is a result of something called Proposition 65, which many of you probably know about, and I won't repeat the Prop 65 story. But Prop 65 has led to some product reformulations. So the idea is, if you think about it, you've got a state that is about, I guess, 1/8 of the world's economy. It's a massive economy, and when they have a labeling provision, there are going to be certain products that say, do we want our product to say on it that we cause cancer? And if we don't, we're going to have to reformulate. So it has had some good, although generally now that I think those warnings are on wine and a lot of other products, the probably impact's diminished.
Just a couple examples that are really quick. Where you have a retail industry that is responsive to consumers, that's going to have a particular effect. So Coca-Cola, the caramel coloring in Diet Coke or Coke, one of them, was carcinogenic, and it was going to be listed under Prop 65, and they quickly moved to change their coloring. And the flame retardants that are used to bind the citrus flavoring to the soda, the bubbly, in certain, I don't know if it's like Mountain Dew or those kinds of drinks. I don't want to, blasphemy Mountain Dew, but that quickly they're doing some research to find some different binding agent than flame retardant. So, where it is going to be responsive and they have a reputation to preserve, that's where it's going to have an effect.
This is a great panel. Ending animal testing is actually an area that is most important to me, but I find it as an attorney the hardest to work on because I don't have a scientific background and my views are seen as so radical. I feel that no animal killing is justified for any means. Just as you would not, we could probably find a cure for cancer if we test on humans, but we're not going to do it because the ends don't justify the means. And so I'm sitting here thinking, how can lawyers get involved? And one thing that occurred to me, and I do have a question that's related to this. I know that in parts of the UK, if alternatives to animal testing are available, they're required to either use it or at least strongly consider it. Here in the US, it's a lot easier to just kind of check off a box and say, I don't really want to do the alternative. So do you think that's maybe an area of future litigation of finding out which, maybe MFA could go undercover and find out which labs are not using alternatives that could be using alternatives, and then we could sue them for. And then that's my question. And I also want to mention my cousin is a huge family. My cousin is a vivisector, and it's very difficult for me. And I tried to talk to her, and because I don't have that background, it's so. There's no, most recently an activist broke into her lab and I asked her the name. I said, so I can defend her. So anyway, I'm really glad to see that there are scientists that are getting involved in the movement. But that's my question. Do you think that's an area of future litigation for us? To be challenging that they should be using the alternatives?
You asked a question that we should have another panel on, and we haven't passed. But thank you for asking it. First, I want to disclose that my philosophy about animals and research is a 3 R's philosophy. So I believe that you should reduce the number of animals, you should replace them whenever possible, and if you have to use them, there are high ethical standards you have to reach. The course I teach at Lewis and Clark, though, has a range of people in it, many of whom have the attitude that you just expressed, which is that all animal testing should be ended now. So my approach is, what I need to do is I need to sort of tell you what the system is. If you want to blow up the system, that's your choice. If you want to defend it, it's your choice. But I'm going to tell you what the system is. The system as it is now, I think you've described well, in that it's hard to get involved. You do have to have some scientific information. But it's not impossible, and we're working on thinking about more ways to get animal lawyers involved in the system. But I don't have a directly good answer for you now. The law does require that when you're using animals that you do look at whether there are non-animal alternatives for your research. And that is supposed to be checked by something called an IAPC, an Institutional Animal Care and Use Committee. Whether that is done well or not well is not something we from the outside can always tell, because those discussions happen at an institutional level. So it's a good question. It's a complex question. I'd be glad to talk with you or whoever else is interested in the audience about it later. But it involves a whole bunch of laws we haven't had a chance to touch on here today as well.
I haven't given enough thought to the legal hooks, and so it is a really, really good question. I would just say 2 things. One is, don't be afraid of science. Every area of law that I've practiced has, and this is the fun of practicing public interest law. I'm going to stand up so I can see you guys. I really think this is important. I've done education work, I've done environmental justice work, I've done healthcare work, and every time I've had to learn something new, I've done family law for that matter. And it's just diving into the details and understanding them and having your experts teach you whatever it is and work with them on it is really the fun of practice. So I'm sure you're not, but just kind of getting that message out. Don't be afraid of the details of the science, because there are people that want to work with you and help you learn it, and that really is the fun of doing the practice. But the only other point I wanted to make is that there are these regimes, whether it's REACH in Europe or in other countries, that are doing better at creating evaluation systems and regulatory systems for chemicals. And the United States is nowhere near where other countries are getting at this point. And in those systems, there are non-duplication clauses and mechanisms for saying you've got to think, you've got to justify any animal studies, kind of for ratcheting up the justification. And those provide some handles, at least in advocacy, for challenging studies that might not be necessary. Under TSCA reform, each of the reform efforts that's been put on the table have included that kind of provision. So Paul mentioned that there are a lot of activity on Capitol Hill. Given that nothing gets done on Capitol Hill, it's not likely to happen soon. But there are drivers for reform long term. And all the proposals have some kind of tiered system of testing and protections to prevent duplication and to create cooperative arrangements where animal testing is deemed appropriate. So thinking about that in the future is part of the whole TSCA reform effort. What is the level of justification? I would just say, as part of having this larger discussion among groups, the part of the issue that I'm trying to get out on the table is, while thinking about protection of lab animals and what should that level of justification be, and when should we try to get legal hooks to
be able to enforce it, to protect animals. We also need to be thinking about how is industry going to use any hook you put in there to prevent regulation. And do we need regulation? How do we make sure that we get some regulatory system to move through so we do something about these, 50,000 or 60,000, whatever number of chemicals that we don't know very much about that are in commerce? So how do we prevent that kind of attack on anything the federal government does to regulate? So that's a balance, and we need to have a conversation about that.
I just want to echo what you were saying. This isn't as much of a question as it is just a statement. But to deal with the fact about this disconnect between feeling like you're qualified to discuss animal testing. I'm only an undergrad, but my best friend's pre-med, and I always have this debate with her on a very low level, and I feel like I have no ground to stand on because she's about to go to med school, and we have discussions about animal testing. And here I am studying social justice, and she just looks at me like, you just don't understand the science. Like, you have no ground to stand on. So, and I feel that frustration, and obviously it's from like a much lower level because I'm not that educated. But I am excited to see animal testing grow into different fields, in the law field, in the science field, and hopefully further fields, because for me it's an issue I'm very passionate about, but I want to be able to talk about it with conviction and data and support behind me, so I'm excited to see. This isn't a question, it's just a thank you. And I think this panel is like the first step to being able to be able to talk about this in an educated manner. I mean, I'm going to go home and tell this to my roommate and explain the best that I can, but this is just a thank you, and I'm excited that this panel happened because it's a way to bring animal testing and different practices and different legislative changes to a broader audience. So, thank you.
So I do, a doctorate in something from Aachen. So I can tell you that I kind of understand what you're saying, that science is often impenetrable. By the way, a lot of the toxicology, I'm holding up by my fingernails too. So don't feel bad. But I will tell you this, echoing what Marion said. Lawyers are good at figuring out systems and asking probing questions. Your education as a lawyer is going to give you that. Ask questions. The other thing I think lawyers are good at is we can kind of tell when people are hiding something. Okay? They use a lot of jargon. They tell you don't understand the science. In my opinion, I tell people when I'm teaching this too, my job is to explain things to you, okay? And a scientist's job should be to explain things to you. Why are they doing what they're doing? And if they say it's because you don't understand the science, I would not consider that adequate. Okay? So use those skills, and there are tools that as a lawyer you can also learn enough about the science. So again, your goal should not necessarily be to understand the science, understand everything that goes on in the laboratory, to be able to operate a GC mass spec. I mean, geez, if you wanted to do that, you would have done that. But you have to know what those things are and what they mean, and you have to ask questions about them. And if you can do that, as Miriam said, your career is going to take you in a lot of different directions. You're going to have to become an instant expert at many things. Being a lawyer will give you those skills.
I just want to add that for people who are worried about this, you don't have to start from scratch, right? So there are organizations in this country, there are anti-vivisection organizations, HSI, departments focusing on the testing question, and especially the interconnection between the science and the law. And so there are resources where you can go on the websites, and they already have fact sheets, they already have programs, they already have reports, and you can pick what you're interested in and find your own entry points. But the good news is people are already trying to, lawyers and activists, non-scientists are already trying to figure this out and translate it for lay folks. So that information is out there if you want to find it. Don't think you're without resources.
To add to that, I actually, my first summer of law school, I interned at the Physicians Committee for Responsible Medicine in D.C. So PCRM.org is their site, and half of their mission as an alternative to the American Medical Association is anti-vivisection work. And they have a few lawyers, and they do participate in litigation. So to directly answer your question about that, I actually wrote you a note that I'll pass you after.
Oh, I think that's a great question too. I'm trying to just think about, well, what would be the claim? And you describe such weak enforcement mechanisms to try to bring some sort of administrative claim saying that the agency had not fulfilled its function to enforce seems unlikely, and I don't see a real basis for suing the manufacturer directly unless the product was found to cause some harm, like in a product's liability type of cause of action. I could see that. I wonder if maybe a different approach that could, or if you have considered, probably I'm sure could speak to is the ability to use these types of animals at all in this setting. I mean, isn't that because rats and mice, which are probably the majority of animals used, are exempt under the Animal Welfare Act? You know, is all of this data and the National Academy finding that animal models are really not valid? You know, is there any drive there to say, well, you know, let's change the Animal Welfare Act then because we really don't need rats and mice anymore? So maybe something like that. And also, I wonder if you could address a two-part question. If the Academy's kind of concluded that they'd rather get away from this type of model, how does that square with things like the Harvard mouse and genetically engineered animals specifically for lab testing? It seems like they've embraced that at the same time as they're distancing themselves from that.
Well, we're starting to get a little more into the complexity, so let me answer your question in two ways. The first thing is, when I think about animals in the laboratory, animals in different research settings, I scale this. So there are animals that have been used in cosmetics testing, although in Europe we're pretty much out of that. And in this country we're pretty much out of that because many companies are multinational. There are animals that are used in toxicity testing. That's what we're talking about here. And I think that we have a very strong case to be made that we can move away from that based on the National Academy of Sciences. There are animals that are used in biomedical research. That is a much tougher area. For a number of reasons. Having to do with the sort of quality of science that you need in order to develop a drug, to understand the disease, to the lack of better models, to an entrenchment in the system. There's an inertia in every system. There is in biomedical research as well. To the laws that govern. So that the first thing is, while if you're talking about cosmetics or toxicity testing, I think you can have a different discussion than if you're talking about biomedical research. The second thing is that and I've had this discussion with a lot of people in the community who are very concerned about animals and research, and it is absolutely true that because of some legislation that was slipped into an appropriations bill, I think a 650-page appropriations bill in 2002 that surprised nobody noticed. Rats, mice, and birds, which make up about 95% of research animals, are exempt from the Animal Welfare Act. Under the Public Health Services Act, which covers research done under the Public Health Services agencies, so any NIH-funded research, they are not exempt. Now that field is regulated in a different way. It's covered under a series of policies and assurances, but rats, mice, and birds are covered. So it's a very mixed picture. It's very, very complex and confusing.
Two quick additions. One is, in the field of toxicity testing, using that taxonomy, while the Academy has recommended moving away, I just want to reinforce the idea that there is not a statement in there that could be judicially enforced that we're at a point where you don't need animal testing. That is, this is a work in progress, and there's investment, but the assays, the validity, the use, the function is still very much itself a subject of science. So you couldn't say, well, this is best practice. The National Academy of Science has said, we don't need this anymore, so you can go to the court and enforce that. It's just not the state of the art yet. It's where we want to go. And there's substantial investment in it, but there's a lot to be worked out. So that's one thing. The other thing I just want to suggest is this is not fee generating, but if there is authority and there's a step that EPA could take within that authority, there's a room for a petition. So if there is a better way to do something and it's within EPA's authority to interpret its mandate as allowing that better way to do something, one way to elevate an issue is to file a petition and say to EPA, through administrative law essentially, to say, you should really interpret your mandate in this way, right? And so you could file a petition going to the way in which EPA is implementing its own authority, or other agencies of federal government is implementing authority to try to restrict the use of animal testing in some way. And then, of course, your handle on a lawsuit would be if they don't respond to your petition in a timely way and you have an unreasonable delay suit, which again is another way of elevating the issue. It doesn't have a lot of teeth to it, but it gets an issue on the table and then it allows you to push for that issue. So, that's another possibility.
We have about 5 more minutes. Any other questions?
Yeah, I mean, paradigmatically, this is also powerful and compelling. I get over the years to hear anyone say, well, they kind of just got it wrong, we don't need to do this. I mean, there's general agreement, and I think Marion had some really nice caveats about metabolism and other things you want to be really sure about and relying on the data. But, I mean, if you look at industry, here's an opportunity to get faster, cheaper data. That's good for industry, it's good for environmentalists. You can get away with sparing animals. More and better data. There's so many positives here. Can you talk a little bit about, if not sort of what's holding things up? Who needs to go first? Does industry need to be making the push? Is it environmentalists who need to kind of buy in more? Is it do the agencies need to not be so nervous? There's so many stakeholders. Who needs to drive this forward? Or is it one of those just all of the above?
Well, I want to just lay out what are some of the things that may be holding it up or why it isn't always perceived as good for everyone. Industry is comfortable, or elements of industry are very comfortable in high throughput testing for screening. So for drug companies, for example, use high throughput testing to look at what drugs might have an effect. But then they get a set of drugs and then they test them in some other way, whether it's animal or epidemiological or whatever, double-blind test, whatever it might be. So there's a comfort level with screening, but not as formal risk assessment on which you base regulation. And then on top of that, kind of the way in which industry might see high throughput testing and what their comfort level might be, depending on the industry. I'm not going to say it's all monolithic. There are real reasons industry might push back at using high throughput testing for risk assessment and regulation beyond screening. So just the way I'm using the words here is in most of the TSCA reform proposals, there's this idea that you'll take all of the chemicals in commerce. You'll do a reset of the inventory of all chemicals in commerce, figure out which ones are in commerce, and then prioritize them. And say, these are likely, based on what we know, hopefully with high throughput testing, these raise some issue of toxicity and persistence, etc. And so we're going to put them in a high priority area. And then these, water, we don't think that there's any worry about them, and we're going to put them in low priority. Once they're in low priority, they stay there until we have more information about them. The high priority test chemicals then, we're going to then do something more. We're going to really test them to find out what's in pathways of exposure, what are the problems associated with them, and only then we'll make an assessment and a determination. Once we make the determination, then we'll figure out whether it's warnings or labels or regulation or bans to try to restrict the harm. So that takes a very long time and it has multiple stages. Industry is quite comfortable. Well, I won't say that. Some aspects of industry are comfortable using high throughput testing on the screening. But if the screens show a lot of chemicals should go in that high priority testing, they're very uncomfortable with that. Because if a lot of chemicals go in high throughput testing, it's like my styrene example. All of a sudden they're worried, people are going to worry that there was a reason it went in high, in this high priority group. So if you label styrene as reasonably anticipated to be a carcinogen, people are going to go, I don't want to use something with styrene, right? And so it's going to have a negative market pressure. So even using the high throughput testing for prioritization makes some people skittish. And then if you go beyond that and using high throughput testing where you're all of a sudden, remember you have thousands of chemicals that have been on the market, people are making money off of them without regulation. And all of a sudden you would have thousands of chemicals that we know that, or we have some reason to believe they may be unsafe or there's reasonable certainty that they're